Hi, good afternoon, everybody. My name is Dominic Wilsden. I'm Curator of Education and Public Programs here at SFMOMA. And it's my colleague, do you want to come and join me? My colleague, Apsara De Quinzio, who is Assistant Curator of Painting and Sculpture here and the curator of the exhibition, The Air We Breathe, which is the kind of the occasion for the discussion that we're going to have, series of discussions we're going to have this afternoon. I'm just going to say a little bit about how this has come about, and then Apsara is going to say a word about the Air We Breathe as an exhibition and as a book, and then I'll explain the format for the afternoon. As you know, the Air We Breathe was a project by Apsara that involved commissioning a number of artists and writers to respond to the topic of marriage equality. It sought to, in a way, extend and develop the vocabulary and the iconography around that issue in some new ways, and in that way, as you say in your introduction, kind of let some more air into the topic and make it expansive and take it in some different directions. The project takes as its premise that marriage equality is an issue of civil rights, and to that extent, seeks to play a role of some kind, and we can discuss what this might be, a role of some kind in the ongoing project to realize marriage equality in this state and in this country. So the topic is something that's not only to be explored in the show, but something through all of us to be achieved. So I'm going to ask Apsara to say a bit more about that project and that show, and then I'll come back in with a couple of words after.
Thanks. Can you hear me okay? So as Dominic said, The Air We Breathe assembles 30 visual artists and 8 poets who were each commissioned to make a new work on the subject of marriage equality for this project. And each person was encouraged to approach the subject in any way that was true to his or her working method. And in a few instances, previously made work was included when relevant. The title of the exhibition, The Air We Breathe, is from a Langston Hughes poem titled Let America Be America Again from 1938. And in that poem, there's a really powerful line that goes, "Equality is in the air we breathe." And in reflecting upon this theme, that line really sort of hit me really powerfully. As everyone in this room knows, over the last decade, equal rights for same-sex couples has proven one of this country's most pressing civil rights issues. And it is a matter that I thought could greatly benefit from the creative reflection of artists and poets. Their original contributions to this project breathe new life into this subject, creating a thoughtful space for discourse to occur. The exhibition aims to foster an open, honest forum that frames the subject of marriage equality in a manner that escapes the polarizing rhetoric of the American political landscape and, in effect, expands the conversation on the subject. And it is my hope that it will provoke and provide a platform and a dynamic space for diverse forms of dialogue to occur. And in essence, that is what we are hoping to do today. A multiplicity of styles and voices was sought for the project. The artists and poets are from all over the US, and many are from abroad, including Great Britain, the Netherlands, Romania, and Colombia. Gay, lesbian, straight, and transgender artists and poets are all present. And most of the contributors approached this subject obliquely, and which is interesting. So much of the work is not necessarily confrontational or inflammatory, but I would say it's more inquisitive and contemplative. And certain themes that recur throughout are love, equality, humor, human connection, anonymity, and a critique of traditional definitions for domestic partnerships. A number of the visual artists incorporate text, leaning on the directness of language, and I think you'll find the poems are actually more direct oftentimes than the visual artworks in the exhibition and book. And other artists and poets, or artists specifically, have drawn on the power of pure visual expression. And many of the works represent gestures between lovers. Uniquely, this project originated as a book and then later became an exhibition. And I think that a lot of the work in the project unfolds over time. And so I think a book is actually a wonderful way to experience this work, perhaps on your own terms, in your own home, sitting on your couch, thinking about the subject. And I actually also conceived of the book as to be used as a kind of gift for people that could benefit from the subjects expressed within it. So I hope you, if you haven't already, you have a chance to see both the book and the exhibition. Thank you.
So what we sought to do with in organizing this set of discussions this afternoon was to take as a starting point the fact this exhibition is some kind of intervention in a field of activity, in a campaign, a movement that has long been underway, and to take a moment to look at the state of that campaign, the state of that large collective shared project, by inviting some individuals who've been in different ways involved in that campaign or have a particular perspective on it, and to discuss the state of things in three key areas: the area of law, the area of culture, and the area of politics, of electoral politics. So the shape of the afternoon is going to consist of those three parts. And the speakers have been paired, and they'll discuss the state of things in each of those areas, and then invite discussion amongst all of us. We're also streaming this online and archiving this for future viewing, and we have also a function online to enable people to submit comments and thoughts. So I'm now going to invite our first two speakers to join us up on stage here, and they are Camilla Taylor from Lambda Legal and Jenny Pizer from the Williams Institute in LA. And you have, I think, a set of full bios on all our speakers. And Jenny and Camilla are going to begin by looking at this issue of marriage equality in the field of law, how that's developed, and where we go from here. Thanks. Camilla and Jenny, please welcome them with me.
Thank you, Dominic, very much.
So we wanted to start with a very quick sense of a little bit who each of us is and how we come to this, and then we'll do a little back and forth to look at where we have been in terms of the law and where we think we are right now, and what we may see ahead. So let me just start by saying that it is always incredibly wonderful to be here in San Francisco, which I think of as the place where I have a body of family, and that I still feel is probably my principal place that I think of as home, notwithstanding having been banished to Los Angeles for 15 years. So much of this movement and the work about family equality has been centered here in San Francisco that it really is fitting to be having this day here in San Francisco. So I'm very grateful to have been invited to participate, and it has sparked for me some reflection on what has been 15 years of being involved with these issues. Actually, if I think about it more personally, more like twice that, as somebody involved very deliberately in a movement and somebody trying to participate by using legal skills, but trying to understand the dynamic that we have in our society, the role of law and politics and culture and education and the work that each of us does. And I should say that, that it is a very personal kind of work for me. I sit here kind of surprised even to be a married lesbian feminist, not somebody who ever thought of myself as being a wife, let alone having a wife, and I find it quite wonderful. And so my thoughts about marriage and family equality are very much a product of seeing myself as a lesbian feminist involved in a movement, and having spent many years working on cases for people whose families were not recognized and protected by the law, and who sometimes behaved not so well toward each other, and have given me a sense of the role of family law as needing to recognize and include and protect all families. And that we call that marriage, and I think it's essential that we all be able to be in it if we want to be, but that nobody be required to be in it if they don't want to be. And I guess just as an additional personal thought, I feel like we'll talk a little bit about the history of how we got here, at the different stages of the struggle. I feel like we're in a phase now where we are able to focus on the expressive role of marriage ceremonies and weddings and the communication function that it can play. So it is particularly fitting that we be here in an institution that's about expression and efforts to help each other understand more deeply things that are so important to us as human beings and to us as we try to build a better society. I do think of our wedding day as among the most precious days in my life, and it was very important that the person who became my mother-in-law was living at the time, and that we were able to have a kind of communication related to that wedding. And the fact that my wife didn't ever get to have a father-in-law because my father had died before that time was a loss. So while we talk about law, I want us to never lose sight of the fact that we're talking about rules and principles and contests in court, but it's always about families that we are building based on love and commitments. And it's important to all of us that we be able to connect each other. We connect ourselves and we connect our families to each other through this set of rules and institutions and rituals. And you know, that's really what it's about. So long introduction, but I think as we talk about history and we talk about the future, let's not lose sight of the reason that we care about all of this. And it's because it's about love and family.
Well, I would like to join Jenny in thanking the museum very much for the opportunity to participate in today and in the celebration of the air that we breathe. I have always felt as though, and I know that Jenny joins me in this, that we are privileged to be part of a very temporary moment when things may still feel uncertain, but before we achieve equality, we have an opportunity to be part of the process of gaining it. We have an opportunity to stand up and to help us get there through raising our voices and through working hard to change the law in some affirmative sense. That's why I went to law school. It was to be part of a social justice movement. And while I'm not a lesbian myself, I'm married to a man as it happens. I felt that this was the best way that I could spend my life, was to try to help bring equality for the lesbian and gay community, and that includes equality in marriage. One of the things that this exhibit does, I think, is provide not just a snapshot of what inspires the most creative and inspired among us, but also it will be extremely interesting, I think, to historians, as historians look back on this temporary moment when things might still seem uncertain before we truly have achieved equality, which we will do before very long. So it's particularly important because it helps inform us about ourselves, and it will help inform, I think, future generations as well, what it felt like when things were still unequal. one of the things that I think is useful about the conversation this afternoon is that we are framing the three questions: where have we come from, where are we now, and where will we go, in different formats. So while we're responsible for speaking about the law, of course the law and social movements are extremely intertwined. And Jenny and I long have felt, both of us, in our legal work to achieve equality, that you cannot go to court without similarly seeking equality in the court of public opinion. You cannot achieve victory in court without creating a climate of receptivity for that victory. And you cannot hold on to victory unless you've achieved public support for what you're doing in court. So these questions are all things that cannot be taken in isolation. So Jenny, would you like to help bring us into the past with the first question? Where have we come from?
Yeah, so here's a quick flyover of a little history. And I often think of the history in terms of decades. It's just a simple way to organize it. Sometimes I think people think that this contest about marriage equality has just kind of erupted in the last couple of years. The reality is that marriage equality for same-sex couples has been a goal of at least some folks within the LGBT movement since the earliest days of the movement. And so if we think of the 70s, there were marriage cases then. They did not succeed. In fact, basically they were not even taken seriously, but a couple of them did lead to legal precedents that we're still dealing with today, needing to dislodge them, get them out of the way as we proceed. But as we look at those cases, some of the arguments then were the same as they are now, that exclusion of same-sex couples is sexual orientation discrimination, and it's a form of sex discrimination that should not be permitted. And while the courts didn't take those arguments seriously then, that was, I think, the beginning of the focus on what the arguments should be, and that courts are always an important part of the work that we do. And we should notice at the same time that there also were other cases going on at that time. Quite a few lesbians and gay men were leaving heterosexual marriages, and many were fighting to retain custody or visitation with their children. So alongside of the marriage cases, sort of on a separate but quite important track, were fights about whether lesbians and gay men are good parents. And those arguments have continued to be important right the way through all of these years. In thinking about this time, sort of retrospectively, can't help noticing that what felt like at the time a gender gap, and is kind of notable over time, that more lesbians were investing energy in trying to retain relationships with their children. Many of the lesbian lawyers were working to try to help lesbians retain custody of their children. In fact, many lesbians went to law school, sort of having become politicized and seeing the role of law in trying to retain relationships with their children. And also we were seeing cases that in some ways seem hard to even imagine today, contests of heterosexual relatives contesting the wills of gay people who had died, male and female, same-sex couples who had written a will where blood relatives would argue too often successfully that the will should be tossed out because it was a product of undue influence on the part of the person who stood to inherit on the person who had passed away. So there were fights about trying to get relationships recognized, fights about parenting, and then some of these cases about marriage. In the 80s, we knew we were making progress in marriage equality cases because we started to get some good dissents. We weren't winning, but we started to get some, we still had these majority decisions that would throw the case out without much explanation, sort of the judicial equivalent of a belly laugh at us, but thoughtful dissents explaining why the claims had merit. And then when we get to the 90s, that's when we started to see success. And folks will probably remember the court decision that really opened up what we think of as the modern chapter of this work, when the Hawaii Supreme Court said, hey, these claims should be taken seriously. And if the state is going to keep this group of people outside of this important social institution, it has to justify doing so. Go have a trial, see if they have a good reason, let's test it in court. And that trial which was held in September of 1996, was a first example of something that we've then seen repeatedly since then, most recently here in San Francisco in the Perry litigation in federal court, when the issues really focused, not solely, but significantly, on the needs of children and whether lesbian and gay couples are good enough parents to be able to be in marriage. What is marriage for, and the role of society in protecting children, and having social science experts testify in court, be cross-examined. Now, in those days, we didn't have nearly as much of what we see today of basically a cottage industry of people who profess social science expertise and who testify sometimes without as much expertise as would be good. And Camilla's going to talk a little bit about that. But during the Hawaii trial, we really had credible, serious experts on both sides, and the experts testifying on behalf of the state under examination came to agree that actually it was not going to serve the interests of children to exclude same-sex couples from marriage, and the trial judge issued a decision laying out findings of fact, which have in some ways guided a lot of work since then, and was a sort of solid recognition of an important part of what we're still working on today. But that trial and the possibility that Hawaii would open marriage to same-sex couples did spark some reaction everywhere else, and I think folks will recall that we saw in 1995, 96, 97, 98, state after state changing their laws, sort of shocked and worried at the idea that there could possibly be married gay people coming into their state and expecting to be treated like other married people. State laws were changed, state constitutions were amended to create a kind of exception that had never existed before. In other words, there's certainly, states have varied enormously about who could get married and which out-of-state marriages would be honored, but we hadn't ever seen a movement before of states kind of passing the baton one to the other of, oh my goodness, there might be some married gay people that want to come into this state. Let's build a wall, widen the moat, and make sure that state law doesn't honor those marriages. And significantly in Congress, the Congress had many things on its plate actually in the summer and early fall of 1996, but was quite concerned that the federal government might be asked to treat married gay people as other married people, and passed the Defense of Marriage Act. And later we'll talk a little bit about where things are now, which is actually some positive momentum. But in September of 1996, there were not hearings, there was not detailed discussion. There was a very quick effort on the part of many of the members of Congress to pass that bill and give it to President Clinton. And the speed with which that was done is part of what the courts are looking at today as that law is being challenged. So let me just flag one or two additional themes as we think about the 1990s and more so the 2000s. People sometimes talk about Vermont being the first state to create a comprehensive recognition for same-sex couples, the civil union law that was developed as the result of litigation that was brought in that state. Litigation was launched in Vermont in significant part to create activity and discussion on the East Coast to sort of show to the country as a whole that this wasn't just about Hawaii sort of being the tail that wags the dog, but actually that these are issues affecting people in many parts of the country, and there were many things about Vermont that made that a sensible place to do litigation. And the Vermont Supreme Court agreed with much that was said in that case, but wasn't quite ready in terms of the functions of government to just order that marriage be open, wanted to engage the legislature in the process of making this change, and the legislature decided to create civil unions. There was a strategic decision made at that point by the lawyers who had brought the case and the couples who were represented in the case to accept that progress that was a partial measure, not a full measure, and drop the litigation and let people get used to the idea that a state could provide the full range of rights and responsibilities to same-sex couples and it would help those couples, and it would not have negative effects on the state. Now, they could have said, wait a minute, our state constitution guarantees us equality. You should let us into the institution that you already have and not bifurcate the rights and responsibilities, this sort of package of legal rights, from the social status and the expressive elements and full equality. You know, we're entitled to better than that. And that was a strategic judgment that people have lots of views on, but I do think history bears out that the fact that states that have followed Vermont's lead, including California in particular, have brought the country forward to sort of recognizing that the needs of same-sex couples are terribly similar to the needs of different-sex couples. And it's taken us to the current moment when enough states have done that experiment, including California, for us now to be able to focus on what is withheld from anyone, same-sex couples in particular, when we're given the rights and responsibilities. We commit to take care of each other, we commit to follow the rules, but we're denied the dignitary aspect of full equality and the ceremonies that have the imprimatur of the state. That strategic decision, you know, could have gone the other way. But I think what we've seen in California is a gradual process of change that has benefited from the idea that we've prompted people to think about, you know, what is this institution for? And why do people care so much about the ceremonial aspects of marriage? And why is it that people want access to the rights and responsibilities? So let me just say, to sort of wrap up the decade by decade timeline, that as folks know, California has been a principal driver of this movement, not the only one, but a principal driver of this movement really from the beginning. And so, you know, I want to sort of flag and let us all be proud of the fact that the concept of domestic partnership was really born here in San Francisco. It was first enacted in West Hollywood because there were some political dynamics here in San Francisco that blocked the first efforts to have a domestic partnership be opened. But it was born here. So was second parent adoption born here in San Francisco. So was equal benefits ordinances for same-sex couples. And in the first half of the 2000s, we saw the domestic partnership concept established at the state level here in California, actually before civil unions existed in Vermont. And it was created in California with an explicit plan to expand that status to do all the sorts of things that the law does for heterosexual couples over time, and that it would be a process of gradual transformation, and that a key part of that approach from the very beginning was a recognition that here in California, all you need to do is sort of blink twice, sneeze, and click your heels together, and you've amended the state law through the initiative process. We all know this. The reality that backlash can happen so quickly and fairly easily here in California was a key part of the decision to use a gradual strategy of shifting public understanding on the issue to try to undermine the likelihood of that. So at the point that Massachusetts was about to open marriage to same-sex couples in 2004, just as the country was sort of waiting for that to take effect, we had San Francisco again kind of leading in a dramatic way on Valentine's Day of 2004 with this city, with Mayor Newsom opening marriage to same-sex couples. And while, you know, our lives are about changing law, as Camilla said, we always recognize that the sort of the power of a legal principle has to be paired with ways of communicating why it matters, what it's about. And I don't know that I can think of many images that I think have had more power to affect understanding on this issue than the Associated Press photograph of Phyllis Lyon and Del Martin after they were legally married here in San Francisco. So we're very aware of pairing a legal principle, which in, I think, US law tends to be a statement of our public morality, with a way of conveying the emotion of it and why it matters. And so to sum up, as we think about these decades, 70s, 80s, 90s, 2000s, and now the, whatever we call this group of decades, the 2010s, I think of it as the idealism of the early phase of what should family law look like. We have an opportunity and maybe a duty as a queer movement to reimagine what family law should be. I feel like it segued into pragmatism in the 80s and 90s of recognizing that people need legal rights and we should use tools that we have to protect people. The understanding of this, I think, became particularly acute for many of us as we saw so many of our brothers dying from AIDS and not having legal protections that were essential. And from pragmatism, I feel like we've moved into a phase now of appreciating the critical importance of celebration. And it's not just legal rights and responsibilities. It's the opportunity to do the celebration of who we are and what our extended families are, and to have our government celebrate that or at least license that and approve that the same way that it approves any other families. So that sort of takes us, in a sense, to 2008 in my mind, if I'm talking about what's happened here in California with the marriages, and then the San Francisco marriages were voided, and then the litigation began, and it took us all the way to May of 2008 when the Supreme Court said we should be able to marry, and many of us did. Some of that the litigation did focus on the needs of couples, the needs of their children, what the law should be. The litigation here was done with a lot of reliance on existing California law. We didn't do a trial. We didn't think there was any need for a trial. We already at that point had the law allowing same-sex couples to take on the same rights and responsibilities. And we already had law from our California Supreme Court that parents have the same rights and responsibilities regardless of sexual orientation. So the litigation here in California was a lot about referring to existing law. But in a couple of other states, in particular New York and Washington, the cases that were done using some similar strategy were not successful. And so as we had wonderful successes at the trial level, I will say. I think our movement we've had some brilliant and eloquent, wonderful decisions from trial courts, but the trick is always to hold on to it on appeal. And in Washington and New York, that was not possible. And so I wanted to turn it to Camilla and ask if you would explain the lessons that were taken from both the successes and the lack of success, looking at 2008, and how those lessons informed a next chapter that you and some colleagues fashioned to look at a different place and look at some different strategy.
Well, thank you. When we look at what the current landscape appears to be at the moment, there are 7 jurisdictions that currently issue marriage licenses to same-sex couples, and those are 6 states in the District of Columbia, in addition, of course, to the 18,000 validly married couples who married here in California. Most of the states in which same-sex couples can marry or are living currently married are on the coasts. But there is one state that stands out as different, and that's Iowa. So I think Iowa illustrates it's a laboratory for showing a number of different themes and a number of different ways in which we approach marriage litigation today. So I'll tell you a little bit about our experience in Iowa to try to illustrate what the current thinking is about bringing these sorts of cases and where we think our successes lie. At the time that we filed suit in Iowa, I'll take it back even further than that. When we first identified Iowa as a place in which we would like to bring suit, that was 2002. We knew that there was marriage litigation proceeding in Massachusetts, but there was no state in the country that at that time allowed same-sex couples to marry. So for a number of folks, not from Iowa perhaps, it struck them as odd that we would consider Iowa to be a likely place for marriage litigation where we thought we could get a victory in the middle of the country. Of course, it was very important for us to get a victory off of the coast because for a lot of people in the Midwest, folks on the coasts are a little odd. And people tend to identify the coasts as places where social change happens a lot more quickly, but they're in the heartland, and the heartland has different values, they would inform you. So we felt it was important to demonstrate that equality in marriage is a principle that has resonance and relevance nationwide, that it is inevitable, that we will achieve it everywhere, and that there are gay and lesbian couples from coast to coast and everywhere in between, and their children, who deserve not just the security and protections that come with being recognized as validly married, but also to be free of the stigma that is imposed upon them when government labels their families as inferior. We identified Iowa in part because Iowa has a tradition of independence and of integrity with respect to moving prior to other states on issues relating to civil rights. And while many people may not be informed about this history, Iowa actually is the first state to admit a woman to the bar to practice law, Arabella Mansfield. Iowa was among the first to desegregate its schools almost 100 years before Brown versus Board of Education did so. As a federal matter, the High Court of Iowa did so by a court order in 1868, I believe. The first published decision in Iowa in 1839 was a case in which the High Court of Iowa refused to return a so-called slave in response to a lawsuit brought by a Missourian who claimed to be his slave owner. The Missourian argued that he had allowed this slave, Ralph, to enter into Iowa to try to earn money to purchase his freedom. And when Ralph had not earned sufficient money in the allotted time, the Missourian sued for his return, and Iowa said, essentially, eviscerating the Fugitive Slave Act by interpretation of federal law, that it would not be party to returning a man to bondage when the man had been permitted to enter into Iowa pursuant to a contract to purchase his freedom. So because he consensually had been allowed to enter Iowa, the state would not participate in returning him. So these are just a few of the decisions that the courts in Iowa made that were remarkable in their time and that are often cited in Iowa decisions as examples of Iowa courts being ready to do the right thing long before the rest of the country was ready. There are numerous other examples as well with respect to the rights of religious minorities as well that the Iowa High Court had stood up for long before other courts in other states had been willing to do that. So we saw Iowa as a likely prospect for that reason. And we also knew that there were a number of couples who'd been approaching us for many years who were confident that they would be treated with respect by their neighbors. So we brought suit there in the hope that that would continue to be true and that we could continue to do public education around the lawsuit and succeed in holding on to a victory if we were fortunate enough to get it. At the time that we did so, as Jenny mentioned, there were a number of very unfortunate decisions that came down in the high courts in other states, Maryland, New York, and Washington State, in which courts had made statements like, well, it's just common sense that a child does best with a married mother and a father, and so therefore we should conclude that a marriage ban could be justified as a way of channeling procreation into certain most beneficial households. And we took a risk in Iowa that we had never done before. We had participated at Lambda Legal in a trial representing the couples in Hawaii that brought out social science evidence in an effort to try to disprove those sorts of arguments. And that was in response to a request, basically, by the High Court of Hawaii to have a trial on those issues. But it's a great big risk when you go to court and ask for a trial at the outset, because if you put on your social scientists, and if there's a court that's not willing to engage with the social science evidence that you're putting before the court, and might be misled by some of what our opponents claim, who have no ethics about mischaracterizing social science data, then you could perhaps have bad findings of social science that might not only hurt us in future litigation efforts, but could be cited against us perhaps in legislatures and in other contexts that would be very damaging. But we realized, because of the language that we were seeing in other high court negative decisions, that it was time for us to take that risk. And we put on a lot of the same social science experts that many of you may be familiar with in the Perry decision. And it was a remarkable decision that we obtained from the High Court in Iowa that resulted in some very fantastic social science findings that have actually helped us to move forward and ask for similar findings in other courts in marriage litigation as we walk forward into the future. So do you want to talk briefly about some future prospects for the movement?
Yeah, I'll just identify a couple of things and hope that folks here have questions and we could do some back and forth about what the future looks like. I think two big areas to mention. Upcoming, in the next year or so, I think we're likely to see efforts sort of based on confidence that we now have a degree of support that we haven't had in the past, that the Washington legislature, leadership there is looking to try to pass a marriage equality bill with an understanding that they would need to then defend it at a popular vote, at a referendum very likely, and so they're proceeding with a sense of confidence that they can do that. Similarly, there are efforts in getting ready in Maryland to do that, and then in the state of Maine, folks have come to feel confident that they can do a ballot measure, a marriage equality ballot measure, to essentially reverse what voters did a couple of years ago there. So that's, I think, a measure of progress. It's political, but these are about legal steps that would be done based on an understanding of support. And then just want to quickly sketch at the federal level. I mentioned the Defense of Marriage Act, federal statute. There is now an effort going on with some actually wonderful momentum in Congress to repeal that measure. The Senate recently held a markup on the bill and passed it out of the Senate Judiciary Committee, which means that the Senate leadership could take up the bill at any time and have a vote. They do have some other things on their docket. I don't think it's going to happen immediately soon, but that is tremendous progress, and there's a bill on the House side with well over 100 co-sponsors. There's also litigation going on. It's at least about a dozen cases in federal courts challenging this statute, including a case here in San Francisco on behalf of one of your fellow San Francisco residents, Karen Golinsky, who's seeking health insurance for her wife. There's the Dragovich case here in San Francisco that's about long-term care. These are practical things that people need. And there are other cases going on across the country. The leading case is in front of the federal court in New England, the First Circuit Court of Appeal, and that's a case where briefs are being filed now. There will be an argument and, a decision maybe in the first half of next year. So that case is really, it's different from the cases we've been talking about in that it is about whether our federal government can treat some married people differently from other married people when the U.S. government has never done that before. And many of us think that litigation, it's very strong, and many of these cases have had an enormous amount of preparation in them. And having a repeal effort going on in Congress while there's litigation in the federal courts makes it a very powerful dynamic back and forth with the different branches of government grappling with these questions. The Perry litigation here in California, I wanted to sort of bring us to the point of focusing on the Perry case, and I'm hoping people will have opinions and questions and things to say about that case. That's a case about getting rid of Prop 8, as we all know. That's about a state's power to allow people to marry or to restrict the ability of some people to marry as tested against the federal Constitution in federal court. Just as of yesterday, there was a ruling from the California Supreme Court. I expect folks have been following it. I think among the things that's been so effective about the Perry case is that it's prompted many people to be looking both at the merits of the case, but also thinking about the relationship between the process of an initiative here in California, what we Californians can do with our votes, how the federal Constitution puts some limits on that, the relationship between the state court system and the federal court system. And I think the bottom line of all of it is that it is awfully easy to change the law in California using the initiative process. The federal courts have been sort of the enforcers of basic federal constitutional principles from the earliest days of the racial justice movement in this country, and testing rights that women need to have under the federal law. So the litigation that's going on here about marriage equality, it's obviously following in that tradition. I believe and I hope that it's also sort of providing a civics lesson that is useful both for our movement but for our country as a whole, because we were created with these grand principles of everybody should be equal. But many of us also feel like we have opinions about everything. We want to be able to vote about everything. We propose to limit the initiative process here in California sometimes, and people say, yeah, it's a terrible system. It's a terrible system. I hate those campaign ads, but actually people do like to vote. And so, my hope is as this case proceeds, it will be not just about enforcing equality for same-sex couples, which is so near and dear to some of our hearts, but also prompting us to think as Americans about what our legal system should be doing, what our political system should be doing, and the constraints that we need to have on each of us if we're going to actually honor the commitments that we should all be equal. Maybe this may be a stopping point, and I hope some of what we have said has inspired some of you to have questions, comments, agreements, or disagreements.
Yes, thank you both so much. I have a couple of questions, or at least one to start with, or just which would be to ask you if Camilla, you said something a little bit about the way in which opponents would misrepresent social science in this process, and I think there's a sense in which the legal process itself gets misrepresented in this, and that the political debate, is this right? Maybe you would say something about it, sometimes turns around that the legitimacy, strange word to use, the legitimacy of legal recourse.
I think that's absolutely right, Dominic. I think there are a couple of themes that we're seeing in terms of how our opponents are characterizing our work in the courts. One of those themes is a sense that the courts themselves are not legitimate, and attacks on the courts. And there have been a couple of examples recently that come to mind very quickly. One, of course, is the attacks here on Judge Walker, who presided over the Perry trial. But we also saw some significant attacks on the courts in Iowa after the decision in Iowa in 2009 that was unanimous when the Iowa High Court struck down Iowa's marriage ban and ordered the issuance of marriage licenses to same-sex couples in Iowa. An Arizona-based organization and an organization based in Georgia began a campaign where they infused $1 million, which is a very large amount of money in Iowa, into trying to get people to vote to refuse to retain 3 of the Iowa justices who happened to be up for a routine retention election in Iowa. And no sitting Iowa Supreme Court justice had ever failed to be retained in one of these retention votes. They're supposed to be votes solely to determine whether a justice is competent, has committed malfeasance. They're not supposed to be a referendum on the outcome in any one particular case. Nevertheless, because retention elections are not something that many of us vote on a great deal, it was a relatively easy target. And these out-of-state organizations managed to get these 3 Iowa justices unseated solely because of their participation in the Iowa marriage case that had resulted in equality in Iowa. And immediately after the election, one of the anti-gay activists who'd participated in this campaign to oust the justices, a fellow named David Barton, who lives in Texas, said that this judicial retention election was the bloody scalp on the gallery rail that would intimidate courts around the country and prevent them from doing the right thing in similar cases involving equality for lesbian and gay persons. So I think that is one trend that we're going to see a whole lot more of as we continue to do our work in the courts for equality. Another theme, though, that plays into that is a theme of misappropriation of victimhood that I think we're seeing throughout the country, in which our opponents are claiming that they actually are the victims because the courts are doing the thing that courts always have been required to do when there's some sort of violation of a constitutional guarantee. I mean, the equality guarantee means nothing if a court is not empowered to strike down legislation, which presumably was supported by the majority, because that legislation unfairly targets a minority for unequal treatment. That's what the equality guarantee in our constitutional system mean. But unfortunately, we're seeing that the folks who are bringing these cases, in many cases, to try to prevent disclosure of donors to organizations that try to bring ballot measures, for example, that would prevent gay and lesbian persons from marrying. These folks are arguing that they are the victims because they would suffer some sort of economic disadvantage if people knew that they had taken positions opposed to equality because people wouldn't frequent their restaurants. So it's a strange way of taking, cloaking themselves with the sense of victimhood, when in fact what they themselves are arguing is that families involving same-sex couples and their children should be designated as inferior by their government, and that government thereby should invite people to discriminate against them.
Let me ask if there are questions or thoughts from here. Sorry? Oh, yes, please.
What did we do wrong? We voted in a Democratic House, Senate, and a president.
Okay, I'm going to have to repeat some of these questions because of the recording, so it was an easy one to repeat, which is, what did we do wrong? We voted in a Democratic House, President, and Senate.
Well, I mean, I think what we saw, if what you're referring to is sort of what happened in the first 2 years of President Obama's administration, and why have we not seen a blossoming of legal protections for LGBT people at the federal level. I mean, I think there's a reality that the country was in an enormous financial crisis, and that there had been many sorts of initiatives that had been blocked. And it is very frustrating to see the number of proposals that are very important to LGBT Americans that were proposed, sometimes incorporated into large bills, and then taken out. I think it is part of a reality that litigation in courts and efforts to enforce equality guarantees will always be a central part of a movement that's representing a quite tiny fraction of the population. You know, some of my colleagues at the Williams Institute are experts in demographic analysis and conclude that we constitute about 3.8% of the population. And so the idea that we've made enough progress to be able to muster support in some legislatures and to be looking at some success with popular ballot measures, I think is a testament to this movement working very hard. Things at the federal level sometimes follow rather than leading. And I think the reality is that a lot of activity is happening at the state level, and a lot more is needed at the state level. And we will get to a point when things will then tip, and the federal government will then drag the rest of the country forward. We've seen it with respect to other movements, and I think that arc is very much the arc of this movement too. But we will be in a better position to demand that folks in Washington be representative and do the things we all need them to do as we have more progress in the states. And that is work that is on everybody's shoulders, you know. And I will say, just as a marker of progress, I alluded earlier to a time when the domestic partnership bill was passed by the San Francisco Board of Supervisors and vetoed by then Mayor Feinstein. And today, Senator Feinstein is lead author of the DOMA repeal bill in the Senate, and she has been wonderfully strong in her expressions of why that bill needs to pass. So I think our movement makes progress, and individual people, just to pick a word, evolve in their views and their sense of responsibility and commitment. And we can call on more leaders, gay and non-gay, to provide that kind of leadership. And let's flag, you know, if we're 3.8% of the population, maybe 9 million out of 370, I think, million people in this country, having allies is a critical part of having success. And whether that is the team of lawyers in the Perry litigation, Ted Olson and David Boies, whether it's people in Congress, there are all sorts of people who are making a difference on these issues, and that's essential, because without allies, we're not going to succeed.
Two more. Absar, you had a thought?
For those people who don't necessarily know what the laws currently are, can you explain how they're written to be discriminating?
His question is, could you explain how the laws at present are written to be discriminating for the benefit of those people who don't know so well that?
Well, historically, marriage is a creature of state law, and this means that each state usually determines what the entry requirements are for marriage, as states historically determined for themselves what the exit requirements for marriage were as well. And so we've seen some distinctions historically between states concerning, for example, what the age of consent is and so on. At the moment, as I mentioned, there are currently 7 jurisdictions, 6 states in the District of Columbia that allow same-sex couples to marry. There are a couple states that don't have statements about whether same-sex couples can marry, and one that actually respects marriages that take place elsewhere. There are a number of states that currently have civil union or domestic partnership laws, so similar to California, states across the country, and soon Delaware and Hawaii as well, allow same-sex couples to enter into schemes that designate same-sex couples as having a lesser status, but nevertheless allow them to access the state law rights, benefits, and responsibilities associated with marriage. And then on a federal level, and then there's, of course, the majority of states actually preclude same-sex couples from marrying as a result of constitutional amendments or statutes, laws that were passed most often in the wake of the 1996 litigation that Jenny mentioned in Hawaii. On the federal level, the federal government purports to deny respect to marriages of same-sex couples, even when they are validly married, as a result of the 1996 law that Jenny referenced, the so-called Defense of Marriage Act, which is currently under challenge in the Ninth Circuit here, in the Galinsky case, a Lambda legal case. And in the First Circuit, in a case that is currently briefed and very close to being decided, in a case brought by a sister organization called GLAD. The name of that case is GIL, and its companion case brought by the state of Massachusetts itself. And then there are a couple of other cases as well in the Second Circuit too. So I think we're likely to see a decision very soon, probably, on a federal level concerning the validity of the so-called Defense of Marriage Act.
Yes, please.
Camilla mentioned that our opponents are claiming they're being victimized. In California, everyone who signs a petition, that person gets privacy. California law does not permit petitions to be made available to the public. Unfortunately, in my opinion, and I want to see if you agree with me or not, in other states, people on our side are putting up web pages where they show the names and addresses of people who signed anti-gay petitions. And the right to privacy has always been something that helped us. I wonder what you think about that.
So questions about the function of the right to privacy and how it's benefiting opponents of marriage equality and in the ways in which they're able to make public those who've signed petitions in support of marriage equality, but doesn't function the same way on the other side.
Well, I would say a couple quick things. One is that I think the most important principle is that whatever the rules are, everybody should follow them. So part of what Camilla was highlighting is a number of recent fights where groups working against domestic partnership rights or marriage rights for same-sex couples have said they should be excused from the rules that apply to everyone else. So whether petitions are kept confidential or made public, I think the first simple principle is everybody should be following the same rules. And if there are campaign disclosure rules, for example, everybody should follow them. And the argument that there is such severe harassment and mistreatment, including, for example, boycotts, which are perfectly legal, that the objection by gay rights proponents is so severe that the anti-gay folks should have special treatment. That, I think, is incorrect, and it's a gross exaggeration of what people claim was done to them, and everybody should be following the same rules. Whether particular parts of the political process should be confidential or not, I think can be a harder question. And you know, generally, I mean, privacy has been enormously important for our community and for many people. It doesn't usually apply quite the same way if one is engaged in a political process. If you send a letter to your representative saying, I think you should vote this way, that's part of a political act, and it wouldn't be kept confidential. It's part of a public record. And so I think you can look at both sides of this, and in fact, in April, the Williams Institute will be holding our annual conference, and this exact theme is a central part of what we're doing. We're having law students from all over the country participate in a moot court looking at exactly that issue, because I think you can look at either side of it. You know, personally, I tend to think that if we're talking about lawmaking, then that should be public. And if you want to make a proposal that the law be changed, then you should do that publicly. At the same time, voting is private, and so whether we consider writing on a petition like a vote or like a statement to a legislator, you can look at it on either side. Whichever way you look at it, I think there are merits on both sides. The rules should apply equally to everyone.
Well, some of the most significant struggles actually take place over donor disclosure laws. So it's not about people simply signing petitions. It's about people wanting to donate significant amounts of money to participate in political campaigns, and then asking that the sunshine provisions that apply to all donations in the political process in a particular state shouldn't apply to them because they're concerned that they may face economic ramifications because they're businesses or whatever. If people were to know that they had participated in this way. And that violates a lot of our most fundamental understandings of what it means to participate in the political process. You can't be exempt simply because you are afraid that people may not like you because of the role that you have played in a particular election. And those are state laws at issue in many different states, and they include Iowa, for example, Rhode Island, Maine, and in every case, actually, courts have decided that there are no real allegations here of victimhood that would justify exemption from one of these generally applicable laws concerning disclosure.
So I think we're going to move to wrap up the first session there, but I would just say one thing that maybe can kind of feed into the discussions following on that strikes me from the way you both approach this. I just get a tremendous sense of both the certainty in final victory that you both have. I mean, Camilla, you pretty much said it right at the beginning, and then combined to that, this seemingly infinite patience with which you seek to develop new and different strategies and amend strategies as necessary. And I don't know. I think I have a sense maybe that sensibility might be something we could come back to in the context of the next two sessions, alongside the cultural and political dimensions of this. But we're gonna take a short sort of 5-minute or so break right now, and then we're gonna hear from Paul Bohnberg and Cleve Jones, and that's going to be introduced by my colleague Frank Schmigel, who will also take that opportunity, I think, to explain something about the set that's behind us here, which is relates to a project by the artist Simon Fujiwara that Frank has commissioned, and that is going to was performed last night and is going to be performed again tonight. But for the moment, thank you, Camilla and Jenny.
Thank you very much.